In this video, I'm going to walk you through exactly what Florida law requires you to maintain, how long you need to keep it, and why this matters more than most business owners realize. If you own or manage a business in Florida, the records you keep today could save you from catastrophic legal and financial problems tomorrow. I'm Santiago Cueto, board-certified international business law expert and best-selling author, and I've spent years helping Florida businesses protect themselves through proper compliance. Let's make sure you're not the next person sitting in my office with a shoebox when you need a filing system. Now, here's what most business owners do not understand. Record keeping isn't just about being organized. I know it's a boring topic, but it needs to be discussed. Under Florida law, it's a legal obligation that directly impacts your liability protection, your tax position, and your ability to defend yourself in disputes. And the requirements are far more specific than you might think. Let's start with corporate minutes and organizational documents, because this is where I see the most dangerous gaps. If you operate as a corporation or LLC in Florida, you're required to maintain records of all shareholder meetings, board meetings, and major corporate actions. Again, you're required to keep these documents. Now, here's the critical part that trips people up. Florida statutes require that these records be kept permanently, not for 7 years, not for 10 years, but permanently. Why does this matter so much? Well, because corporate minutes are the primary evidence that you're operating your business as a separate legal entity. When someone sues your business and tries to pierce the corporate veil to go after your personal assets, one of the first things they'll look for is whether you maintained proper corporate formalities. Now, if you can't produce meeting minutes showing that you held annual meetings, documented major decisions, or kept your corporate and personal affairs separate, a court might decide that your LLC or corporation is just your alter ego. At that point, your liability protection evaporates, meaning you just lose it. They can go after your personal assets. Now, I've seen this happen. A real estate developer in Miami lost his personal home because he couldn't produce corporate minutes showing that his LLC was legitimately operated as a separate legal entity. The plaintiff's attorney argued successfully that the LLC was a sham, and suddenly everything the developer owned was fair game. That's $1 million mistake that proper record keeping would have prevented. And it's not just meeting minutes. You need to maintain your articles of incorporation or organization, your bylaws or operating agreement, stock certificates or membership interest records, and any amendments to those documents. These aren't suggestions. They're the foundation of your legal existence as a business entity here in Florida. Now let's talk about financial records, because this is where federal and state requirements intersect in ways that can create serious exposure. The general rule in Florida is that you need to keep financial records for at least 7 years, but that's actually the floor, not the ceiling. And certain records need to be kept much longer. Your tax returns and supporting documentation, that means your profit and loss statements, balance sheets, general ledgers, and all receipts and invoices need to be maintained for at least 7 years from the date you filed the return. Well, why 7 years? Well, because that's how long the IRS has to audit you in case of substantial underreporting of income. And Florida's Department of Revenue follows similar timeframes for state tax matters. But here's where it gets more nuanced. For certain types of records, 7 years isn't enough. If you have any employment tax records, and we'll get deeper into employee files in a moment, the IRS recommends keeping those for at least 4 years after the tax becomes due or is paid, whichever is later. But if you have any retirement or pension plan documents, you need to keep those permanently. Property records, including records of asset purchases and sales, should be kept for at least 7 years after you dispose of the property, because you'll need them to calculate gain or loss and defend your tax position if they're challenged. And this is crucial. If you ever file a fraudulent return or don't file at all, there's no statute of limitations on that. The IRS can come after you decades later, which means you'd better have records going back to the beginning of time. I'm not saying you're going to commit fraud, but I'm saying that accusations of fraud do happen. And when they do, having comprehensive records is your best defense. There's nothing better than that. Now, if you're finding this information valuable and want to make sure you're protecting your business the right way, do me a favor and hit that like button right now. It helps other Florida business owners find this content. And if you haven't subscribed yet, click that subscribe button so you don't miss future videos on business law topics that could save you significant money and legal headaches. Now let's move on to employee files. because this is an area where both state and federal laws create a complex web of retention requirements, and the penalties for getting it wrong can be severe. Under both Florida law and federal regulations, you're required to maintain specific employment records for varying time periods, and the retention period depends on the type of record. Well, let's start with the basics. I know it's getting complicated. Personnel files containing job applications, resumes, hiring documents, and performance reviews, disciplinary actions, and termination records should be kept for at least 4 years after the employee leaves. Why 4 years? Because that's the statute of limitations for most employment discrimination claims under federal law. Now, if a former employee files a discrimination lawsuit against you, you're going to need those records to defend yourself. But certain employment records have different retention periods. Payroll records, including time cards, wage rate tables, and records of wage deductions, must be kept for at least 3 years under the Fair Labor Standards Act. I-9 forms must be retained for 3 years after the date of hire or 1 year after termination, whichever is later. Now, if you're subject to Family Medical Leave Act requirements, you need to keep FMLA records for 3 years. Now, here's what keeps me up at night for my clients. Workplace injury records under OSHA must be maintained for 5 years, and if you have exposure to hazardous substances, some health records must be kept for 30 years or the duration of employment plus 30 years. And if you have a retirement plan, those records need to be kept permanently. Now, the common thread here is that these retention requirements exist because disputes often arise years after the events in question. An employee might not file a wage claim until they've left your company. A discrimination allegation might not surface until you've hired their replacement. An OSHA investigation might not occur until long after an incident. If you can't produce the records when these situations arise, you're essentially defenseless and you're likely to lose simply by default. I worked with a restaurant owner in Tampa who faced a wage and hour lawsuit from multiple former employees claiming they weren't paid for overtime. He knew he'd paid them correctly, but he destroyed the time records after 2 years because he thought that was long enough. Huge mistake. Without those records, he couldn't prove what actually happened, and he ended up settling for far more than he would have owed if the claims had been legitimate. The records would have protected him, but they were gone. Now, beyond these major categories, there are other records you need to maintain. Business licenses and permits should be kept permanently. Contracts and agreements should be kept for at least 7 years after they expire or are fulfilled. Insurance policies should be kept permanently. Any records related to loans or debts should be kept until the debt is paid off, plus 7 years. And any records related to litigation or potential litigation should be kept until the matter is fully resolved, plus 7 years. So here's the bottom line. Proper record keeping isn't optional, and it's not something you can fix retroactively when a problem arises. The records you maintain today are the evidence you'll need tomorrow when the IRS audits you, when a former employee files a claim, when a shareholder demands accountability, or when someone tries to pierce your corporate veil and go after your personal assets. My recommendation is to implement a document retention policy right now. Don't wait. Create a system, whether it's physical filing cabinets or digital storage, all these that organizes your records by category and retention period. Set reminders to review and purge documents that have exceeded the retention period, because keeping unnecessary records can also create problems by increasing what you have to produce in discovery in case you're sued. And most importantly, make record keeping a routine part of your business operations, not something you think about once a year. Hold those annual meetings and document them. Keep those receipts and invoices organized. Maintain those employee files properly. It seems mundane until the day it saves your business. Now, if this video helped you understand what you need to be doing differently, make sure you hit that like button so more business owners can find this information. And subscribe to this channel for more practical legal guidance that protects your business and your assets. I'm Santiago Cueto, your Florida business attorney. Be sure to watch this next video for more business law insights.